This podcast is not intended as legal advice. If you're in need of legal services, please contact 602-375-6752 to set up a consultation. You're listening to the official podcast of the Law Office of Libby Banks, Estate Planning, Wills, and Trusts. Your estate planning attorneys in the Phoenix Valley.
Hi, I'm Libby Banks. Welcome to the podcast of the Law Office of Libby Banks. I'm here with my associate attorney.
Hi, I'm Allison Gloss.
And with Kent Berk with Berk Law Group. Welcome, Kent.
Oh, it's my pleasure. It's great to have an opportunity to sit down, handling litigation, only like seeing things after the fact. I look forward to a discussion today about ways to protect people from being taken advantage of.
I appreciate that very much. So we invited Kent today because he does the things that we don't do. As our clients know and people who refer us know, we don't do contested matters. So we will handle an ordinary probate or trust administration, but if there's some kind of a dispute or a contest, we're going to refer it right over to Kent Berk and his team. We also don't do guardianship or conservatorship, but that is something that we can refer to Kent to work with us for those occasions when that's part of the plan that we're putting together. He also talks about today and handles financial exploitation, particularly of elderly adults, but also vulnerable adults, and also abuse and neglect. So he's going to talk a little bit about how do we even deal with those types of problems that sometimes seem so prevalent these days. So a little bit about Kent. So he's been in practice, I believe, since 1992 and started his firm in 1996. He quickly realized that his best practice and what he was best at and would contribute most to society was exactly what he's doing now. So he's been building his team out since then, and we're so happy to have him here. On a personal note, he's married. He has 2 granddaughters, me too. So I always like to mention the grandkids.
The bright spot of life right now.
Right. He was the founder of the Arizona on the Rocks, which is an indoor climbing gym. So that's why he looks so fit. And Pure Pickleball LLC. So we know 2 of the things you like to do right there.
Yeah, to stay active. So.
Awesome. Well, one of the questions that we have for you is one that we get a lot from our clients, and that is about the no contest clause. That clause that we always put in all our trusts and wills saying, what's going to happen if somebody contests the will or contests the trust? And we try to explain to them it's not rock solid. If somebody contests but they have a good reason, they may not get cut out of the will or the trust. So I thought maybe from your perspective as the person who litigates those, we'd love to hear your thoughts about when does the contest clause really affect the person who is bringing that contest, and when is it possible that that person would still receive their share of the estate?
Sure. Yeah, this is a common question, and it's often misunderstood. People think that they can be disinherited under a no contest clause no matter the level of merit in their claim. So even if they think that they have like a successful, clear-cut claim that their loved one was taken advantage of or unduly influenced, that, the will contains a no contest clause, so I can't challenge it. And that's not the case. So let me just back up for a second. Arizona allows a trustor or a will maker, or somebody who's writing a will or a trust, to include a no contest clause. And those are enforceable under Arizona law unless the person had what's called probable cause to bring the fight. And it's important to keep in mind no contest clauses in the context of the overall purpose of probate law. The primary purpose of probate law is to ascertain and give effect to the will maker or the trustor's intent, and not just any intent, it's their intent for the disposition of their property. And so a no contest clause is supposed to effectuate that. And as you know, people include no contest clauses mainly because they want their intent to be followed, and they don't want their estate or their will to be bogged down in litigation. They want their assets to pass efficiently and quickly according to their wishes, according to their true wishes. And theoretically, a contest or a challenge is going to delay that and may sidestep or try to sidestep what their true intentions are. But what if their intentions have actually been tampered with, where they lack mental capacity or they've been unduly influenced? So the law for no contest clauses basically has to balance the trustor's intent of enforcing the no contest clause and prohibiting any challenges against the possibility that there actually could be a legitimate challenge, and it's necessary to bring the challenge or the contest, whatever the case might be, in order to actually ascertain and fulfill their true intentions. And that's why you have this window of probable cause. If you have probable cause, then you can bring the challenge. And even if you lose, you're not disinherited.
That's great. So a question that I'll ask, and this is probably more for lawyers, but hopefully will be of interest to our audience today. Some of us put in a statement of intent in the trust or in the will. So, and some attorneys are really encouraging of doing that. My concern always has been, if I'm working with a client who says, my intent is to disinherit this child because I've been estranged from them, they're, alcoholic, druggy, whatever it is, that if that situation has changed, that actually gives the child a better standing in terms of contesting it, because they can say, that was the intent then, but we had reunited. I'm clean now, and I should get my share, whatever that is.
Yeah, I could see the point, but the person's intent is gauged by what the will reflects at the time that it was executed. And many people, unfortunately, change their mind but never get to the point of effectuating that intent in a new document. And secondly, you can't necessarily rule out the possibility that they're saying something to, let's say, one child, but actually intending to do another in order to preserve the peace, like while they're still living. They may not want a child that they've disinherited to know that they truly intend and will be disinheriting that person for whatever reason. So even though they're saying, oh, yeah, I love you and I want you to be in my estate, it really doesn't matter unless they really mean it, and more importantly, that they actually effectuate it. But kind of along the same lines, an interesting issue arises where a will reflects different intents. So a will has different mechanisms, right? Different parts. One is who's going to get what. Another is who's going to be appointed, let's say, as the personal representative or executor in order to effectuate that transfer. So what if you have a contest of who should be appointed as the personal representative, and can that be used to disinherit someone under a no contest clause, even if it's undisputed that the person's dispositive intent of who wants to get the property is to the person who's challenging the personal representative appointment. And what I always go back to in that situation is the purpose of probate law is to ascertain and give effect, again, not to just any intent, to the dispositive intent of who gets what, who gets the property. And so I would say fighting over who the PR should be isn't the kind of thing that could subvert who gets the property, even if it's a clear-cut contest in violation of the no contest clause, by fighting over who should be the personal representative.
And particularly if the personal representative is not performing, is not doing what they're supposed to be doing, or is taking assets, which we've seen from time to time. Sometimes it's just we can't even get in touch with the personal representative that we helped get appointed. And, the beneficiaries are entitled to a personal representative or a trustee that gets the job done and follows the rules about what they're supposed to do.
Yeah, so theoretically, even a PR who's not doing their job, if someone tries to remove them, theoretically that could be a contest depending on the language in the will or the trust, and that unless they had probable cause, they could be disinherited for contesting who should be the personal representative or executor. Again, even if it's clear cut who's supposed to get the property, that could end up to be subverted or avoided just because of a side issue, a side battle.
Yeah. Well, thinking about battles over the personal representative or trustee not doing what they're supposed to, I did have a future trustee say to me the other day, so I was talking to my friend and he said, well, when I'm trustee, I can just do whatever I want. I don't think that's right. So from your standpoint, as the person who litigates potentially against a trustee who's just doing whatever he wants, I'd love to have you speak to our audience about that.
Yeah, absolutely. And it comes up not just for trustees, though. It's anybody acting in a fiduciary capacity, whether it's a personal representative, an agent under a power of attorney, or a trustee under a trust. They all involve fiduciary positions that have heightened levels of duty, including a duty of loyalty, a duty of transparency, record keeping, accounting, the duty to inform and report, among other things. So you most certainly, when you're serving in those roles, cannot do anything. In fact, you need to follow the document, and you can really get into hot water if you do things that are not just in violation of the document, but really anything that benefits you as the trustee or fiduciary or your family could be wrong under the law unless it's specifically and explicitly permitted in the trust or the power of attorney.
Absolutely. So important to pick somebody who actually understands that regardless of what their friends are saying.
Yeah, and it's important to read the document, make sure you're following what the document says, and consult with an attorney. And, advice I typically give to fiduciary, so anybody that's serving, like I said, in personal representative, trustee, or agent, or guardian, conservator, any sort of a fiduciary role, it's better to ask for permission than forgiveness. So if there is a transaction that could, let's say, potentially slightly benefit you as a trustee or your family, or something else that isn't explicitly and very clearly allowed under the document, go to court and get permission from the court. Or another way to protect against potential problems is be transparent with the entire family and make sure everybody is on board that this is what mom or dad wanted, or is permitted under, if there's a gray area in the document that it's unclear. Get everybody's agreement, preferably in advance, because when you start doing things as a fiduciary behind people's backs, they're going to suspect the worst, and they're going to usually believe that there's wrongdoing and set off, some sort of a dispute or fight that could be avoided if you're proactive. And like I said, asking for permission than forgiveness.
Yeah, we often do agreements ahead of time. I'll let Allison speak a little to that, because we have everybody sign off on it if there's a gray area, or, for instance, the trustee is purchasing a property.
But going back to your question about like precatory language, or just indicating what the intentions are in a will or a trust, even if it's not part of the dispositive provisions, and explaining the trustor's intentions does have its benefits, but you got to be clear if it's just explaining versus an operative provision in the will. And I would say for a no contest clause, it's important to be particularly explicit on what is the prohibited conduct and what the consequences are from that. Because in that area, if you're not clear, the court could say, well, because it's a penalty clause, the court won't necessarily construe it narrowly, but forfeitures under a penalty clause are frowned on and disfavored. So you need to make sure that that clause is clear, because if it's not, then the court may not give effect to a no contest clause that, the drafting, the client would otherwise really want.
Right. And Whenever the beneficiaries and the trustee want to do a distribution that does not align with the plan, we typically do a family agreement and have everybody sign off on it. Particularly when it's been coming up is when there's an adult child living in the house that the parents owned. And everybody's supposed to get the proceeds from the sale of the house, but there's somebody living in the house. So that's been coming up quite frequently.
Yeah, I think a family settlement agreement is great. Another mechanism that you could use is going to court and filing a petition for instructions and just asking the court, hey, everybody agrees, but we just want to make sure that this is legitimate, and just get that court order to make sure that it's not going to backfire, later, whatever the transaction is.
Yeah, especially with the probate, since we're already in court, that's even easier. So definitely.
Have there been any cases that have stood out to you and kind of made an impression on you throughout your career?
Well,
that you could speak to?
Yeah, there's a lot of them, but one in particular that kind of ties in with your question about I'm trustee, so I can kind of do anything. That's not the case, but a blatant example of that is an unreported decision. It's a Rodriguez case. There, some caregivers expended a vulnerable adult's money to make improvements to the home. They put in an accessibility ramp, maybe made some changes to the bathroom, an accessibility shower, and other improvements for like $30,000. But they couldn't account for all of the money, even though it was obvious that they had spent money. You could see it in the house. But because they didn't keep a ledger and couldn't account for it, they were basically presumed to have committed financial exploitation and found liable to disgorge and give back the amount they couldn't account for, and ordered to pay attorney's fees of the estate. Even though it was like, by all accounts, they were providing good care. There wasn't the ordinary, they told, the vulnerable adult wanted to buy me a car, or they gave me an extra check for $10,000 because they said I did a good job, or the typical things that are like, yeah, right, kind of a thing. This was all apparently legitimate, and it was just because they could not account for it, and because a fiduciary has a duty to account. If you don't account for money that you receive in that role, you're presumed basically to have misappropriated it. And so that's a blatant example of even a trustee with honest intentions that's trying to do a good job can get into trouble. So you need to really pay attention and follow the rules and account and make sure you're using, the assets for the benefit. And the reason why that strikes me is, again, because by all accounts, everything went according to plan, and there was significant money that was spent. And I don't think there was any evidence of actual misappropriation, where they couldn't find any money that actually went to the caregivers for an improper purpose.
So accounting and record keeping, so important.
Yeah.
Absolutely.
Yeah,
Absolutely.
And it's really scary because the Adult Protective Services Act, which we're going to talk a little bit about, in a second, is basically a strict liability statute. It's not, I thought it was okay and it's okay. No, you don't. That's not an excuse.
Why don't we segue into that? Tell us a little bit more about that act and what it says and what it means for us and for our trustees.
So it's a really important statute that Arizona has. It's called the Arizona Adult Protective Services Act. And there's several components. One of them deals with financial exploitation of vulnerable adults. And then another one deals with physical abuse or neglect of vulnerable adults. And this is a big problem. I looked up the statistics this morning from the reporting dashboard of Arizona Adult Protective Services Department. And in the years 2023 and 24, so the last 2 years, they had combined reports of over 42,000 cases of reported abuse, neglect, or exploitation. And in both of those years, about 25% of the cases involved reports of exploitation, financial misconduct. But I think that those statistics, and most people agree, are way underreported due to the fact that, by definition, somebody who's vulnerable and being taken advantage of are likely going to be isolated and secluded and may have no real ability physically or mentally to even know what's going on, let alone to reach out for help. But another factor that is sometimes overlooked is the embarrassment factor, that people who are becoming impaired, they don't necessarily want to go to their friends or family or the court and say, I'm a vulnerable adult and I need help. It's a tough thing. But the reporting statistics are improving with more public awareness about these laws and the mechanisms to report misconduct and follow up and follow through in the investigations, as well as staffing and other considerations. So that's just the basics of the act. And I think today you wanted to talk about ideas on how people can protect their loved ones from exploitation, abuse, and neglect. And I have several ideas that we're going to share here in a few minutes, but I just published an article on our website, on our resources on the FAQ page, a detailed article of a lot of solid ideas. I think there's 7 of them with a lot of explanation of ideas of how people can be proactive and protect their loved ones from being taken advantage of.
Great. And so I'm just going to read out your website, so people wanting to see that, www.berk, B-E-R-K, lawgroup.com. So that sounds like a great article. I'm going to go look at that myself.
Thank you. Yeah, and so I can quickly go through like some tips. One of them is to educate the vulnerable adults and family about common scenarios. Like, what are people seeing out there that they could be taken advantage of? One of the common scams is a grandchild calling and saying, hey, Grandma, I'm in jail. I need you to come and give me $10,000 to bail me out. Oh, is this Hannah? Is this whoever? Oh, yeah, it's Hannah. And then they fall for it. And next thing you know, they're out $10,000 or whatever. And this is all too common. There's a lot of scams that are online, and you can't believe the things that people will go to convince vulnerable adults, whether it's relationship scams or claiming that the police are going to come and arrest somebody who's impaired and thinking that it's true and giving money. I've even had cases that are so blatant where the vulnerable adult was contacted by a state of Arizona, I think it was an attorney general investigator, a detective that came in, showed his badge, and said, these people that are defrauding you out of this money, they had been tipped off through the bank through some red flag. And the detective went out to the person who's being exploited and said, they're like in Nigeria defrauding you. There's no person that's going to come and send the international police or whatever it was. And they still kept giving money. And we had to pursue a conservatorship on the person to basically get control of their own money away from them to protect them from being exploited. So education, sign up for the Do Not Call registry, pay attention to your caller ID, be aware of artificial intelligence and the possibility of voice recognition and somebody sounding familiar when it's really not them. Be skeptical, ask questions, don't do anything on the first call, and follow up with somebody who's calling you saying that they're from Microsoft and you need to update your license or, whatever the case is. But it's almost unimaginable, the variety of scams that are out there. But education is really important to prevention. I'd say a second really important one is to monitor financial accounts. It's really easy with a lot of financial institutions to set up different alerts. And I think some institutions will allow you to set up alerts that will be to someone other than the account holder. If that's a problem, the vulnerable adult could add an agent under a power of attorney or, someone else with the right account agreement terms to monitor the account and that kind of thing, and be aware of any financial activity. Also monitoring credit reporting, that kind of thing, and appointing a trusted individual to monitor accounts if there is an impaired individual. Another really scary thing is fraudulent deeds or property, basically real property, basically being stolen. There's even a reported decision recently of where a forged deed, literally a forged deed, was recorded, and the forger paid all the property taxes for whatever it was, 5 years or something like that. And then the actual property owner found out about it and filed an action to quiet title. And I believe the court said it was too late. There was a recorded deed, and under the statute, if they pay the property taxes, taxes for a certain amount of time, you're out of luck.
Wow.
And so
That's
monitor
so
the property records. There's a lot of counties now where you can sign up for alerts and you can check and make sure that you're still shown as the recipient for your property tax bills and so forth.
Yeah. Yeah. Maricopa County Assessor has that. So I did sign up, and I did get an alert for Elizabeth Banks, because that's my legal name. But it was way out in Sun City, and I don't have property out there. So that was okay. But it was nice to see that alert really did show up very quickly. And I think then the other thing is for both adults who might get taken advantage of, but also their families, to make sure those taxes are being paid, and by whom. So there's something to say there, is just to make sure, is mom paying her taxes at all? Because we also see that happen where nobody's paying the taxes and somebody tries to get that tax deed by just paying the taxes and then trying to foreclose on their tax lien. And, as you said, monitoring the bank accounts and making sure that there's not money going out. I had a financial advisor who's a friend who realized that one of her clients had some money going out, that when she talked with the client about why did she withdraw this money, the client really wasn't all there or aware, and was helped through the reporting through the Adult Protective Services to get some help for that person as well. So there are ways to make sure, at least be alerted to problems that might be arising.
Yeah.
Those are great tips.
So a few other tips here real quick. As I'm sure you recommend to all of your clients, establish a power of attorney, appoint a trusted individual to manage your affairs either now or at a later time when you become incapacitated. But it's not just that. I think it's important to select a trusted individual, but also to educate them and make sure they understand the kind of things we were talking about earlier, the fiduciary duties of keeping records, making sure that the agent under the power of attorney knows that they can't just do any transactions at all. It has to be, like I said, specifically and explicitly authorized in the power of attorney or some other, governing document. Watch the mail. Watch the mail for any suspicious activity. If the adult is vulnerable and not able to manage their own mail, you can set up a mail forwarding and have all of their mail forwarded to a P.O. box or another trusted family member or the agent under the power of attorney. I think it's also real important to foster open communication, like educate and foster open communication with the loved ones, usually the elderly, vulnerable parent. Hey, mom and dad, watch out for these things. And if you do get a call, just let me help you with it and approach it from that perspective, and maybe even reassure the individual to not be embarrassed and just to let them know that there's a lot of scammers out there that are just really good at what they do. And a lot of people to the tune of billions of dollars are scammed every year out of these kinds of things. It's amazing.
I fell victim to a bank scam that was so sophisticated, it was insane. So
Yeah.
I feel that on a personal level.
Yeah.
So.
We had a family member who, luckily not living alone, but appeared to be living alone during that week period. And a roofer came to the door and said, hey, we're doing roofs in the area. If you want, we can just take a look at your roof to see how it's doing. Of course, they went up and found, so much damage, and we're going to have to do a complete replacement. Left a couple tile samples and planning to come back. The daughter came home, and mom luckily had not signed anything or given any money yet. So, but she called that guy and said, we have our own roofer. Thank you very much.
Yeah.
And of course, there was no damage whatsoever. So,
all kinds of things like that.
Yeah.
Yeah, we had a client too whose spouse was really ill for about 6 months, and they had around-the-clock care coming into the house, and these caregivers had stolen the client's identity and gone into purses and pulled out credit cards and racked up a bunch of debt on those. So Really scary.
And thinking about credit cards, one of the other things that people can do, even for our age, might be a good idea, is freeze their credit. So that's always a good idea, so that somebody can't steal the identity and open new credit cards along the way.
So just a couple of final tips. Seek professional advice. If you're concerned about exploitation, see an attorney. Also, report to the Adult Protective Services Act. You can go to 1-877-SOS-ADULT or 877-767-2385, or on their website, you can also report and learn more about Adult Protective Services and the Act at des.az.gov. And like I said, you can report suspicious activity there or gain more information.
Awesome. Well, Kent, thank you so much for sharing your expertise with us and with our audience. We really appreciate you coming here. That's another episode of the Law Office of Libby Banks podcast. We hope you'll join us again next month.
Thank you, Libby. My pleasure.
Thank you for listening to the official podcast of the Law Office of Libby Banks. If you're in need of an estate plan, please reach out to our team by either calling 602-375-6752 or emailing info@libbybanks.com. You can follow us on Instagram and Facebook. Just search the Law Office of Libby Banks. Free consultations apply to new and existing estate plans only. If an estate plan is not completed or was prepared by a third party, revisions will be given at an hourly rate. This has been a T-Door production. Music by Track Tribe.